The potential overturning of the Chevron Doctrine by the U.S. Supreme Court could have far-reaching implications for environmental policymaking and regulation. Established in the 1984 case, Chevron v. National Resources Defense Council, the doctrine allows federal agencies to interpret ambiguous statutes as long as their interpretation is reasonable. Critics argue that this grants excessive power to unaccountable agency bureaucrats, leads to inconsistent policy, and conflicts with judicial principles established in Marbury v. Madison. They believe that courts, not agencies, should have the final say on statutory interpretation. Supporters of Chevron contend that Congress often leaves ambiguities in statutes, intentionally or not, and that elected administrations should have the power to interpret these ambiguities to advance their policy objectives. They argue that agencies are better equipped with the expertise necessary to handle complex regulatory issues and are subject to oversight from various entities, including Congress. Overturning Chevron could shift significant power to the judiciary and limit the government's ability to respond to new scientific and technological developments. The case is currently before the Supreme Court. Loper Bright Enterprises v. Raimondo and Relentless Inconties v. Department of Commerce, brought by commercial fishing groups against a National Marine Fisheries Service rule, could pave the way for the potential repeal of Chevron. If overturned, it could lead to more litigation, less regulatory flexibility, and increased judicial involvement in policy decisions traditionally handled by experts in the executive branch. This change may destabilize regulatory environments, impacting sectors from environmental protection to public health regulations, and could have mixed consequences for businesses dependent on stable regulatory frameworks. Proponents of maintaining Chevron emphasize that agencies, due to their specialized knowledge and ability to adapt to new circumstances, should retain interpretative authority in cases of statutory ambiguity. They fear that eliminating Chevron would result in a rigid and outdated regulatory system, hindered by an inability to evolve with new information and societal needs. Moreover, they argue that agency-led interpretations ensure more democratic accountability compared to judicial decisions. The Supreme Court's decision in the upcoming cases will be pivotal in determining the future of federal regulatory authority and environmental policy.